There are different kinds of contracts, and each one has unique terms and conditions that are attached to the needs of the parties who are negotiating it. Even so, some commonalities are discovered when the discrepancies are taken into account. Classification of contracts can be done on the basis of how they are formed, whether they are valid, basis of their nature, and on the basis of their execution. Given that most contracts can be of many different sorts, a contract, for instance, could be verbal, legal, and unilateral. Thus, each of the aforementioned categories is distinct and crucial. Contracts can be formed in several ways. Firstly, contracts on the basis of its formation. Under this, contract can be classified into the following types. The first one is verbal contracts. Verbal or oral contracts formed through oral communication are often difficult to prove in courts. The Delhi High Court in Nanak Builders and Investors Private Limited versus Vinod Kumar in 1991 noted that an oral agreement can be legitimate and enforceable but not in writing unless required by law or parties intentionally reduce terms. For example, Robert and Anna are having dinner and he asks her to lend him some cash to get a new car. She agrees as long as he pays her back all the income by the end of the year with 10% interest. That's offer and acceptance, consideration and intention to be legally bound, which makes it a valid verbal contract. The second one is written contracts. Written contracts are those that are take a written and concrete form. Currently, these are the contracts that are most frequently used. They become legally binding contracts whenever they satisfy the requirements of Section 10. For example, A made contract with B by writing that the conditions and dates on the paper that he will sell his property to B for rupees 50,000. B accepts the condition of the contract by signing the contract. The third one is express contracts. Ex, ex, The third one is express contracts. Express contracts are created through the submission of offers and the acceptance of those offers. The acceptance of proposals may be expressed or implicit. A proposition is an express offer when it is made in writing, in accordance with Section 9 of the Indian Contract Act. As a result, an express contract is created by verbal or written communication. For example, A asks B whether he would like to sell his house for an X amount. B agrees to the same by saying yes. This is an example of express contract. Thus, an express contract, the terms of the contract are clearly expressed. The fourth one is quasi-contract. Quasi means seemingly. Thus, sometimes contract can create rights and duties. These form what are referred to as quasi-contracts. For example, if a person A is not competent to contract and dependent on that person B who supplies him all the necessaries of life, then the person B who supplying the same will be entitled to reimbursement from the property of the incompetent person. So, even though no contract is there between A and B, B can ask for compensation or reimbursement so that they are not negatively affected. The last one under this category is e-contracts. An electronic contract is a contract that is created through online transactions. E-contracts are not expressly recognized by the Indian Contract Act. They are not, however, prohibited at the same time. The requirement of free consent, which is frequently found in e-contracts, is one of the requirements of the valid contract under Section 10 of the Indian Contract Act. For example, a consumer using an ATM to withdraw money is an example of an electronic contract. When a person orders goods through an online shopping website, this is an example of an e-contract. Second category is on the basis of validity of contracts. Under this category, contracts can be classified into firstly, valid contracts. Section 10 provides certain essentials for valid contracts. That is, there must be free consent between the parties involved. Then the parties must be competent to enter into a contract. Then the consideration and object of the contract should be lawful. And lastly, the contract must not be declared void under the law. Secondly, void contracts. Section 2J says that a contract that ceases to be enforceable by law is void from the moment it becomes unenforceable. The term void in laws means not legally binding or invalid. Apart from the above, the following are the certain other conditions of void contracts. Section 20 states that an agreement becomes void when there is a mistake of act concerning an essential facet of the agreement. It is important to note that a mistake of law does not make a contract void, nor does a one-sided mistake make it void. According to section 24, a contract with an illegal object or consideration is void. Section 25 states that an agreement without consideration is void unless it is writing and registered, or is a promise to compensate for something done, or is a promise to pay for a debt barred by limitation of law. Section 26 says that agreements in restraint of marriage are void. Section 27 says that agreements in restraint of trade are void. Section 28 makes a contract void if it is in restraint of legal proceedings. Section 29 makes a contract void if the meaning of the agreement cannot be made certain. Thirdly, voidable contracts. Voidable contracts are those contracts that can be made void on the will of one of the parties. In these scenarios, generally consent is not free and it is obtained under coercion, that is under section 15, undue influence, that is under section 17, fraud, that is under section 17, and misrepresentation, that is under section 18. Here the parties defrauded or unduly influenced has the option to make the contract void. Fourthly, void ab initio contract. These are special type of void contract that means void from the very beginning. In essence, void ab initio contracts are those contracts that never existed from the moment of their inception. The most common example of a void ab initio contract is one made by a minor. In Moiri Bibi versus Dharmodas Ghosh case, it was declared conclusively that minor contracts are void ab initio. Fifthly, illegal contracts. Contracts that violate the law of the land are illegal contracts. Section 10 states that the object or consideration of a contract should be unlawful. Thus, Section 10 prohibits illegal contracts. For example, contracts killing facilitated by contracts for murderer are illegal as murder is a crime under Section 302 of the Indian Penal Code. Another category is on the basis of the nature of the contracts. Under this category, contracts can be classified into firstly, unilateral contracts. Unilateral contracts, as their name suggests, are agreements in which one side makes a commitment. The contract is fulfilled by performance and there is no mention of the other party. Before performance is made, the offerer cannot be asked to fulfill a request. For example, X offers to pay Y rupees 10,000 if he mows his lawn by the end of week. Y accept the offer and create a unilateral contract. Until Y completes the tasks, there is no binding contract and X is not obligated to pay him. However, once Y mows the land, the contract is formed and X is under contractual obligation to pay him the specific amount he promises to pay as per the terms of the offer, or he be in breach of contract. The second one is bilateral contracts. These are the agreements where both parties make reciprocal pledges. As a result, the contract is created through the exchange of offers and acceptance. These agreements, often known as two-sided contracts. For example, any sales agreement is an example of a bilateral contract. Thirdly, unconscionable contracts. Unconscionable contracts cannot be enforced by the law. An unconscionable contract will undoubtedly be ruled void by the court of law if a lawsuit is filed against it. No monetary compensation is given, but the parties are liberated from their contractual obligations. The court will decide whether a contract is unconscionable or not. For example, an unconscionable contract occurs when one party is experienced dealer in a certain type of business and the other party is an average customer. Fourthly, addition contracts. An addition contract, sometimes known as boilerplate contract or a standard form contract. It is a contract between two parties in which one party with greater bargaining strength establishes all or most of the contract's provision. The opposite party with less bargaining strength has little or no leverage to reach an acceptable agreement. For example, Megnan needed to buy software to ensure that she could keep up with all of her office tasks while also coordinating with the other project personnel. However, the software included a potentially dangerous condition that allowed the employer to take a screenshot of the system whenever they wanted. As a result, control would remain in the hands of the project manager. Megnan had no choice but to accept the terms to keep working. As a result, the agreement might be considered as addition contract. Fifthly, aleatory contract. This is a type of contract where parties involved do not need to perform a contract until a specific event occurs. These events are generally those which cannot be controlled by the parties involved. For example, most common type of aleatory contract is an insurance contract. Here, insurance premiums are paid without any kind of performance from the insurance company. Sixthly, option contracts. Option contracts enable one party to enter into a new contract with a different party at a later date. Exercising the option means entering into a second contract. For example, in real estate, where a prospective buyer will pay a seller to remove a property from the market, then have a new contract formed to buy the property outright at a later date if they desire. The last category is on the basis of execution of contract. Under this category, contracts can be classified into firstly executory contracts. These are the contracts that are continuing in nature. For example, a lease agreement. Here, throughout the term of the contract, the owner would allow the tenant to stay in the former's property and the tenant would pay monthly rent. Secondly, executed contract. These are the contract whose obligation has been fulfilled. For example, the purchase of a product or service is an executed contract.